Good morning, my magnificent young entrepreneurs. Are you ready to learn some law and make some money? Okay, today we're going to start our two sections on torts. The first section is going to be intentional torts, and the second section is going to be negligence and strict liability. A tort, before I started studying law, I thought a tort was a delicious chocolate and cherry-covered dessert. But we're not talking about that kind of tort here. In the law, a tort is an action, either intentional wrongful act or an act of carelessness that causes somebody an injury or damage to their property for which the law recognizes they have a right to compensation. So that is a tort, and torts include things like personal injury cases, car accident cases. For a lot of trial lawyers, this is where the big bucks lawsuits are. So it's very important for you to know about torts, because if you own a business and word gets around town that you make a lot of money, two things are going to happen. One is people are going to start imitating your business model and trying to rip off your customers and your service or your product. And the second one is you become a target for lawsuits because you are now what is called by lawyers a deep pocket. You have money, other people want a little piece of your money, they will begin to look for excuses to sue you. So you must know tort law and how to protect yourself from lawsuits. We're going to start with the intentional torts. And intentional torts are where the wrongful act that you do is done on purpose rather than by carelessness. So on the list of intentional torts is assault and battery, false imprisonment, infliction of emotional distress, defamation, invasion of privacy, and fraud. So let's look at the first two of these, assault and battery. For a test in this class, you must be able to distinguish between assault and battery, and the distinction is fairly simple. An assault is a threat of physical violence that puts you in imminent fear of serious bodily harm. So if we were in class and I came up to you as a student in the class and I had a big baseball bat in my hand and I said, if you don't shut up, I'm going to bash your head in with this baseball bat. Most of you would probably laugh at me because you know I would never do that. And besides, you're young and strong and I'm old and fat. You could probably take me even with a baseball bat. So most of you would laugh. But if I did put you in imminent fear of serious bodily harm, it doesn't matter whether I touched you or not. No physical touching is required. The assault in the tort world is just the threat of physical violence. No physical touching is actually necessary in order for me to be liable to you for a lawsuit for assault. So, and you see in the movies all the time, you see the cops saying assault and battery. Well, that's the crimes of assault and battery. But in the tort world, a civil lawsuit world, assault is a threat that puts you in imminent fear of serious bodily harm, and no physical touching is involved. A battery, on the other hand, is a tort where there is a non-consented, offensive physical touching. So if I punch you in the mouth or I hit you with a baseball bat, that's a battery, and I have liability for that, but it's an offensive, non-consented physical touching. You have to watch out for that, because it's not just punching a guy in the mouth or hitting him on the head with a baseball bat. It may also be an offensive sexual groping. You smack some gal on the rear end and she's not your girlfriend and doesn't consent to that. Watch out, you could be sued for battery for that offensive, non-consented touching. Now, one other interesting thing about battery that might surprise you is battery often comes up as an additional claim in a lawsuit for medical malpractice. Well, how does that happen? Well, if I take a surgical knife and I cut you without your consent, that would be an offensive, non-consented touching. That would be a battery. And you say, well, what's that got to do with medical treatment? Because obviously that's always consented. Well, the problem is a lot of times before a surgery, the doctor comes in. He doesn't come in at all. He sends some medical assistant with the form, the release form, to consent to the surgery, and he says, here, sign this. And no one explains to you the risks involved in the surgery. And so when you sign the release and you have not been advised by anyone about the risks involved in the surgery, then a legal argument can be made that you did sign the consent, but it was not a fully informed consent, so that consent doesn't count. And then therefore when the doctor performs a surgery on you, it's a non-consented offensive physical touching, and people have sued doctors in medical malpractice cases for battery as well as for medical malpractice. That's pretty much it for assault and battery, except that there are defenses to a claim for battery, and one of them is there was a consent. So if you smack your girlfriend on the rear end, and maybe she likes that, she's consented to it. Not likely, by the way, but if the touching is consented to, then it's not offensive. Self-defense. You can use self-defense to defend yourself if you're being attacked, and you can also, it's also a defense if you're using physical force to defend somebody else that's being attacked. The defense of property. You can use a limited amount of physical force to protect your property, but here's where we get into sticky legal areas, and this is the reason why we don't see store security guards carrying guns. We do not shoot people to death for stealing a candy bar. The physical property is not regarded as important as a human life. So you can only use a reasonable amount of force to defend property, and the law is very clear on that. And in fact, some of the landmark cases in this area, one of them is the famous spring gun case. And in the spring gun case, there was a farmer who had a little old house down by the highway, and as he became more successful, he built himself a nice big house that was way back down the road, down near the center of his property and a ways back from the highway. He didn't know what to do with the little house down by the highway, so he used that to store his farming equipment. And but the problem was that people kept, he couldn't see the little house down by the highway from his big house that was way back from down the road. And so people kept breaking into the little house and stealing his tools and his farm equipment, and it made him very angry. He made a number of reports to the police. They couldn't catch anybody doing it. And so finally he said, well, the next guy that breaks into my little house down there to steal my stuff is really going to get it. So he put a chair and he lined up a shotgun and duct taped it to the chair, so it's pointing right at the front door of the little house. And he ran a string from the trigger of the shotgun over to the doorknob, and he said, the next guy that breaks into my little house and comes through that front door is going to get a shotgun blast. Sure enough, somebody broke in there and got shot, and the man was prosecuted for a crime because we say you can't kill people in defense of property. Now, and then we end up with all the urban legend stuff about if you shoot a burglar that's trying to break into your house, be sure you drag him inside, because if you shoot him inside it's okay, and if you shoot him outside it's not okay. I do not recommend shooting somebody and then leaving a blood trail as you drag him inside your house and saying that's okay because he was inside. The critical factor there is, were you in fear for safety of your life or safety of your family? If this burglar was burglarizing your home and put you in fear of your physical safety, then whether he's inside or outside, the shooting may be justified. But of course, that's always going to be up to a prosecutor and a law enforcement officer and a jury. So if you don't have to shoot somebody, don't shoot them. There is one pretty funny case about that. Oh, I know what I was going to say. That's why with regard to burglary, if a burglar burglarizes a commercial property, a warehouse or a store, the criminal penalty is not nearly as bad as it is as if he burglarizes a house, because a house is a man's castle. It's the shelter, the safety place for your family. And if you invade a man's house, you're much more likely to have some kind of serious violent incidents or a shooting because you're threatening people's safety, threatening their shelter. But with regard to shooting people to protect property, the law on that appears to vary a bit from one state to another, and it kind of depends on what state you live in. Because there's a fascinating case out of Texas where an old guy is sitting home watching TV, and he looks out the side window and he sees two burglars breaking into his neighbor's house, breaking into the side window. And so he calls the police, and the police dispatcher says, we're sending some police, don't go outside, don't do anything, and just wait. So this old guy waits, and he's watching these two guys break into his neighbor's house, and he calls the dispatcher back and he says, it's been 10 minutes and no police are here, and you know, my neighbor's gone on vacation and he asked me to watch his house for him, and these guys have the screen off the window now, and they're getting ready to go inside, and I'm going out there and I'm going to stop them. I'm not letting this happen. So the old guy takes his shotgun out, and he sees the two burglars there, and one of them's halfway through the window. He takes sight on that guy and boom, blows him away halfway through the window with his shotgun. The second guy, who was helping the first guy get through the window, sees a shooting and takes off terrified, running across the front lawn to get away. He's running away. The old guy sights in on him with his shotgun and boom, blows him away in the back as he's running away. And then the police arrive. And the police say, you can't do that. You can't shoot people to death just because they're breaking into your neighbor's house. You can't shoot people over property. So they charge him with a crime. And the old guy said, I'm not guilty of anything. I'm going to trial. He went to trial, and the Texas jury said, nah, we're okay with that. So I guess if you're in Texas, you could shoot people to defend your property. But I would not recommend that in California.